Hello, everyone, and welcome to Stress-Free IEP, the show where we help families build their village to raise their neurodivergent children with confidence and support. I'm your host, Frances Shefter, special education attorney, advocate, and fellow parent, walking this journey with you. Each week, we shine a light on the professionals, resources, and real-world strategies that can empower you to navigate the IEP process and beyond without stress. Whether you're tuning in live on Facebook or YouTube or listening later on your favorite podcast app, we're so glad you're here. So, as you can see, I'm solo today. Unfortunately, Andrea Svedensen, and I know I'm pronouncing that wrong, Svedensen and Associates she's sick today. So instead of canceling the show, because I know a lot of people registered and were interested, especially going into IEP season right now, I am going to give you the top 10 legal tips for a successful IEP meeting. The number one is to know your legal right to meaningful participation. And what does that mean? So under IDEA, parents are equal members of the IEP team. I know the schools never make you feel like it, but you are an equal member. You have the right to ask questions, request clarification, and insist on explanations supported by data, not just their opinions. And you also have the right to obtain documents in advance of the meeting so you can fully prepare. Meaningful participation means you know going in what they're thinking in the extent of what data they have to support everything. That means they need to provide that to you so that you have an idea of how to agree with or potentially disagree with what they're proposing. And that comes to number 2, which is bring and use your own data. So your observations and records carry legal weight. You can present progress notes, medical evaluations, behavior logs, and all of these data points can either be from your own observations or private providers or even the schools. Courts and hearing officers consider parent-provided data as part of the record if disputes arise. So it's equally important to make sure that you have data supporting everything, so that if it does get to the legal point, you can make your arguments of like, well, but they sent progress notes that said da 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 da, or I've observed the child do this, or their private speech pathologist says they can do that, so that you can dispute anything the school might be saying. Number 3, request, or I should do number 3 in the sign language way, request all documents in advance. Legally, schools must provide a letter of invitation. So that's the first document when the meeting is scheduled. And this should be 10 days in advance. Schools have to give you 10 days notice, unless you waive that, to have a meeting. On the letter of invitation should have the date, the time, the location, these days, whether it's virtual or in school, and the purpose of the meeting. And that's extremely important to know, what is the purpose of the meeting? Are we just doing an annual IEP review? Okay, then we need teacher reports and a draft IEP in advance. Are we doing an evaluation review? Okay, then we need all of the reports of the evaluations that were done. Are we doing an evaluation planning meeting? Okay, so then we need previous evaluations and probably progress notes and teacher reports to see whether additional data is going to be needed and make our recommendations for what evaluations we might want based on the data. So, as I said, the school must provide you draft IEPs, evaluations, and any other documents being discussed prior to the meeting. So IDEA, in typical format, says reasonable time. So what is reasonable time in advance? Maryland law says that 5 days before or reasonable time. Virginia says 3 days before or reasonable time. And DC is usually 5 days before. So what does that mean? It means that you need to make sure that the school has to provide you documents in advance of a meeting so that you can prepare and be ready to discuss it. I've had at IEP meetings before, the schools go, oh, well, we're going to review this document. Well, we didn't get that in advance. Now, depending on what the document is, sometimes I'm okay with it. Sometimes I'm like, you know what? We're not going to discuss that now because A, it wasn't on the letter of invitation of the purpose, and B, we didn't have it in advance. So I'm not going to try to do this on the fly. It really depends on what the outcome you want of the meeting and what the purpose of the meeting is and what the document is. And also, if you're in agreement with what's been going on or you're already getting into an adversarial position, also makes a difference. Here's what to do with the documents in advance. Review them all carefully and annotate and prepare questions. When I prepare for IEP meetings, either my own children's or when I'm preparing for clients' IEP meetings, on my IEP, I take notes in red and I highlight things I have questions about, and I'm very specific about everything. So that when the school tries to put something in, I know that like I've had time to think it through and my client and I have discussed it. Then during the IEP meeting, usually what I do is I'll do in blue. I'll write my comments. I have Adobe. I'll put my comments in when I, do it. I'll put my comments in so that like we agreed to this, we agreed to that, so that when I get an updated draft IEP, I can compare. The other thing that I do sometimes is I tell the school, as long as it's okay with my client, do you want me to send you my notes? And the schools are always like, oh, thank you, because they want to make sure that we all are in agreement and that it looks the same. If not, we're going back and forth, making changes, making amendments. The other important reason to have all the documents in advance is so you're not pressured into making a decision without like having full information. And that goes back to your meaningful participation. Like if you don't have the full data, full information of what's going on, how can you make a true decision that impacts your child, the rest of your child's life, right? You need to have that data so that you can feel comfortable in decisions that you're making for your child. Specificity in the IEP. Insist on it. There are so many areas that the schools are not very specific. So starting with present levels. Present levels should be specific. Copying out the MAP scores or the iReady scores or the DIBBLE scores and just putting all the scores there tells you nothing. When you read your present levels, you should be able to say, yeah, that's my child. That's how my child learns. It needs to be, their strengths, their weaknesses. If they are doing something, this is extremely important also. If they are able to do something, are they doing that with supports, without supports, with prompting, without prompting? It makes a difference. Saying a child is currently buttoning their own shirt when we're talking about our younger kids, okay, great. But does that mean the teacher needs to prompt them? The teacher needs to start it? Or is the child doing it independently? Those few words are really important to get the full picture of your child. Vague accommodations, breaks as needed. Well, how is that enforceable? Well, we didn't know the child needed it, so we didn't give them any breaks. That doesn't work. You need to push for clear language. When, how often, and by whom the support will be delivered. A lot of IEPs have those sections, but then there's also clarify location and manner. I've seen way too many times in that section across all settings. That's not clarifying anything. We need it to be specific in the supplemental aids and services. What exactly does this look like? So reinforce positive behaviors, clarify location and manner. What are the positive behaviors we're having an issue with? Is this a child that's not sitting in their seat? Then when the child is sitting appropriately in their seat, now what praise works for this child? Thumbs up, a nod, a sticker, a touch on the shoulder. Every child's different, and we need to know what works for your child so that the teacher or paraeducator or anyone else in the classroom and interacting with your child knows how to interact. What I like to say is the stranger test. Can a new person, a brand new teacher comes in, pick up this IEP and know what your child is, who your child is as a learner, and how to implement the supplementary aids and services, how to support your child to meet the goals. If you don't understand it, guess what? A new teacher won't understand it. So ask for clarification. Ask for, well, what does that mean exactly? What does that look like for my child? It's individual for a reason. Document everything. If you've ever talked to a lawyer or know a lawyer, we all say document, document, document. And so how is that done? So if you make a request and the school says no, automatically, please make sure that's noted in the prior written notice that I requested it, you denied it, and the reason that you denied it. Because the prior written notice is everything it's so important because it's like what happened at the meeting and it's the school's justification for doing things. If the school sends you a prior written notice and it doesn't have everything, send an email. By law, they're supposed to amend it. But at least if you have an email saying, I requested this at the meeting and the school denied it, please update the prior written notice of why the school denied this request. Then you at least have that email to show if it gets to litigation or a state complaint that I requested that they changed it. This wasn't right. And so it supports your position even more. And that's also comes to when you have a phone conversation or a quick conversation in the hallway, document it in an email. Because who's, he said, she said, who are they going to believe? But if you're able, well, I sent an email to person A that said, just want to confirm this is what was discussed. This is what we decided. These are the next steps. You sent the email to them. Whether they respond or not doesn't necessarily matter, because if they don't respond, then, well, if you didn't respond, we're going to assume it's all correct. If it wasn't correct, then you would have emailed me back and corrected, saying, well, no, we thought it was this, and have that discussion. And so again, this supports your position and gives you the legal strength for your arguments if it gets to that point. Use the law as a shield and a sword. And I know you're going, I don't know the law, but I don't know the law. Guess what? That's okay. Most of the times, the people at the IEP meeting, the schools, they don't know the law either. I mean, I could tell you stories from when I was a teacher back then that I thought I was following the law. That's what I was always told. And then I went to law school and started learning the real law and went, oh, that might have not been as legal as we thought it was. But we didn't know. We're not lawyers at that point. Neither is the school sitting at the table. So how do you use the law if you don't know the entire law? You ask the team, oh, I didn't know that you couldn't do that. Can you please show me in IDEA or the state regulations where it says that? Because I'd like to learn so I understand what the schools are legally able to do or not do. Chances are they can't. And so then it's, okay, well, if that's the case, what are you basing that decision on? Where is it saying that you can't do this? And they might say, well, it's our policy. Well, that's nice. Policy isn't law. This is an individual education plan. What my child needs takes priority over policy. And there's a lot of times I've seen policies that directly conflict with the law. So what's the law? What supports your decision? Where are you getting this from that you can't do this? And then looking at that, like schools like to say, well, funding, we don't have the resources. That's not your problem as the parent. The school needs to figure it out. Central office needs to figure it out. If your child needs these supports and the team agrees your child needs these supports, saying we don't have the funding is not acceptable. They get funding from the federal government and the states to provide these services of what your child needs. They need to figure it out and budget better. Number 7, recognize legal buzzwords. So schools like to say the data shows in order to support IEP goals, services, and even placement. Legally, you can, and you should ask, what data do you have to support that statement? This comes back to number 2 about bringing your own data and using the school's data to support your own position. I always love doing that. The school says, well, it's showing, the data is showing that he's struggling in the class and he's not reaching his goals. Wait, what? So last month, you all sent me progress notes that said making sufficient progress to meet goals for all 5 of his goals. So where is this data now coming from saying that he's not making progress? And it's their data. They can't argue their own data, and you have that support. Another one is the behavior charts. Well, his behavior is indicating we need a more restrictive environment. Wait a minute. We have weekly communication. All of his behavior charts are showing improvement. I've charted it out here. Previously, he's had, 5 bad days every 2 weeks. Now he's only having 2 bad days every 2 weeks. This is showing that he's making improvement. So what data is showing that we need a more restrictive environment? And it's just putting that there. You can also use the data, from what your providers see. Another legal buzzword that I like to use often, and I shouldn't say legal, it's just buzzwords that I like to use as an attorney. Schools often like to say, well, there's no educational impact when discussing eligibility. Your child is getting all A's and B's and is on or above grade level. Okay, but my child is missing 50% of the school day, or my child is missing 50% of each class. Here are the words that you use to respond to that. My child is not available for learning when my child is not in class. That is why there's educational impact. If my child's not in class available for learning, there's educational impact. How do we support that? The other one I use often is masking all day. A lot of our neurodiverse kids, especially our kids, twice exceptional or 2E kids, mask. They're very good at fitting in. I'm supposed to be like this, and this is how I'm going to be. Well, guess what? All of their energy is on what they should be doing. They are not fully paying attention to learning. So they're not available for learning. The other thing is that your child might come home and fall apart. Why? Because for 8 hours, they just kept themselves together and had to fake it to fit in, mask to fit in. And schools like to say, well, that's a home problem. That's not our problem. And the idea is, no, it's a school problem because my child has to mask all day and doesn't get the supports they need. And so when they come home, they fall apart because they now they can be themselves. And that is such a release that they fall apart. And it's not fair to my child to put them through that. So if we were to put supports in place, sensory breaks, movement breaks, teaching how coping strategies is a big one. Let's teach coping strategies so that my child can cope and function as themselves in the classroom every day and not masked, not having to mask. Number 8, communicate proactively and consistently. So communication is huge. We know that. How do we communicate? How do we get it? How do we get on the right foot? So and I'm really bad at this. I don't even necessarily always do it for my children, but from the start of the year, set up periodic check-ins. I always say, provide the teachers my child in a nutshell. So I don't always get it out in writing, but at least at open house, or back to school night, I talk to the teacher, real quick. Hey, my child needs a safe space that she, a dark corner that nobody can see her, but she's still in earshot. Where's your space? How did you create that? And then we have a discussion, because that's one of the huge things for my child is that when she dysregulates and she needs to flight, because she's a flight, not a freeze, or a fight, although sometimes, she needs a place to fly to. And so where is she going to go to that's a safe place that everybody's agreed on and she knows about? And so I set that up at the very beginning of the year, make sure the teacher is aware of, and what does that look like? And then that it's communicated to my daughter. So what is it that your child needs in a nutshell? Email it to your teachers in the beginning. I like to say, potentially like a one-page document. I wouldn't do it much more than that because I'm telling you, as a former teacher, they're not going to read it. Highlight the key parts of the IEP. What's most important so that your child has a successful year? Because starting off on the right foot with everyone benefits everyone. The teacher now knows you're a concerned parent and an involved parent, and you will team with the teacher to make sure everything's good for everyone. And, what's the most important thing for your child? Is it whatever you do, don't touch my child? And not in the sense of, obviously, we know not touching, but some kids don't even like a tap on the shoulder or a pat on the head. It triggers something. And so that's something a teacher should know, because innocently a teacher could walk by and put a hand on your kid's shoulder and set something off without even knowing. And so if that's something that's really important, make sure that that's communicated to the teacher at the very beginning. If your kid is struggling, with something of like, hey, this is happening and I'm having a hard time and my kid's having a hard time, what can we do to make this work? My child missed some school and some assignments are missing. How can we make up these assignments? Because he or she is feeling very overwhelmed with how much work to make up. What can we do to make it better? Can we excuse the assignments? Can he or she do half the assignment? Or can we have an extension so I can work with my child on the weekend? Whatever it is, it sets up that communication with the family, with the teachers, that, hey, I'm a parent that cares. Not saying all of us don't care, but I'm a parent that's very involved and I want to work with you so that we're all successful. Number 9, and this is important, know when to bring support. When do you bring support? When you say, I can't do this anymore. When you're up all night stressing about it. When you know that the school is going to recommend something that you disagree with. So legally, you can bring any advocate, attorney, or even other experts to a meeting. You can even bring your aunt who's a former teacher or your best friend just to sit with you so you're not feeling alone at the table. Whatever it is, you can bring a person. Just let the school know. They do, usually on the letters of invitation they have, I'm bringing these people. Attorneys, you must let them know, but if you hire an attorney, they'll tell you that, because most schools will not have a meeting with a parent attorney if they don't have their own attorneys there. So when else? If the school's not listening to you, if you're not feeling heard in an IEP meeting, if you feel your child's not making progress, or if you feel that this isn't the right fit for my child anymore and the school's giving me pushback, having representation strengthens your position. And here's why. So having an attorney, once you get to this point of disputes, it's going to bring people from central office. And as I said, is the school's attorney. And what does that do? A lot of times people from central office have suggestions or know things that can be done that the school level team might not know. It also helps because legal makes sure the school is doing things legally, not just how they want to. For example, when the school keeps saying, we can't afford it, we can't afford it, we can't afford it. And yes, I actually had an IEP meeting where a principal kept saying that. And the attorney for the school system said, Ms. Shefter, can I have a minute with my client? Went off record. I know exactly what he said to the client is, you can't say that, and had that discussion. And so that's where it comes out like, okay, so can't afford it is not the reason. Do we need this? Does my child need this extra support? Yes. Okay. Central office will figure it out. So it's again, way to get you the extra support because you have the legal team there and central office there that can do more than the school-based team. And then number 10, stay professional, but assertive. Here's what I say. You're still a parent. It's still emotional. I still get emotional at my kids' IEPs, every single one of them, because it's hard. This is not easy. We don't want our kids to struggle. but we also want to make sure the school is providing their supports as possible, as much support as possible, so that our child doesn't struggle as much. So you can be in your emotions. What I like to tell parents when they engage with us is like, you don't have to stay professional. You can be the parent. You can say whatever you want. There's nothing you can say in an IEP meeting that I, as your attorney, can't say what my client is trying to say and put it in the words that we need to get what we want on the IEP and the placement. And so IEP meetings are supposed to be collaborative by design. We're all a team. We all work together. The focus is my child. And as a team, we are going to come up with the best individual education plan possible for my child. I say best, but as much as possible. As you know, schools don't have to provide the best education. They have to provide adequate, and that Supreme Court said it is. Don't have to provide Cadillac. Pontiac is good enough. So, but in that sense of as much as we can to support my child, that they can be successful where they are. So that's it. Our 10 legal tips of how to have a successful IEP meeting. Please note on my website, there will be a handout soon so that you have this all on one sheet. I will have it downloadable. Right now, I do have it downloadable about empowering parents, how to prepare for an IEP meeting that goes into more detail than this. It was an hour-long presentation that I did for X-Minds. So make sure that you check out the website. And with that, thank you all for joining us on this episode of Stress-Free IEP. We hope today's conversation gave you new tools, insights, or just a little more peace of mind as you support your neurodivergent child. Don't forget to subscribe so you never miss an episode. And if you found this episode helpful, please share it with someone in your village. You can always learn more and connect with me at shefterlaw.com or follow along on social media. Remember, until next time, you do not have to do it all alone.